Us now, Art Thou, to talk more about this is Alex Little, a defense attorney and former assistant federal prosecutor. So, Alex, good morning. Is Rudy right, or is he wrong on the law?
The letter's not particularly persuasive as a matter of law. It's persuasive on some points, but realistically, this is an attempt to sort of slow things down, I suspect. They sent it back in January. They've managed to slow down the process. We're now in the 1st of June, and so it's had that intended effect. But telling a prosecutor, hey, you don't really need this information, is not going to be very effective. The prosecutor's asking for it because they think they need it. Here, Robert Mueller believes he needs to sit down and talk to the president. And so they're going to either at some point decide to do it or not, and there's going to either be a subpoena or not. And at that point, I expect, if you believe Rudy Giuliani, this is going to go to court.
What do you think is persuasive about it?
Well, I think the idea that the president does play a special role in the hierarchy of the federal government, he does hold the executive power individually, is a point that's been upheld by the courts for decades. The difficult part is there are particular ways that he has to effectuate that power. Here he's got an attorney general who is overseeing this investigation. Now, this attorney general has recused himself, and so that's been delegated to the deputy, but he can't essentially enforce actions unless he goes through those constitutionally appointed officers. And I think that's a real problem for him here, is that ultimately, if Rosenstein says, yes, you can do this, special counsel, and issue that subpoena, he's under the Constitution authorized to do that, and the president can't do much about it.
And you know that's going to go to court. I mean, Rudy says, and the lawyers say they're going to litigate this. Let me read a paragraph from the letter, first one, and get your reaction to that. They claim, quote, that every action that the president took was taken with full constitutional authority pursuant to Article 2 of the United States Constitution. As such, these actions cannot constitute obstruction, whether viewed separately or even as a totality. I mean, are they right on that any action the president takes is constitutionally correct?
No, that goes back to the Nixonian idea that the president does it, it's not illegal. If there was a witness who was going to sort of talk about bribery in the White House and bribes that had taken place, and the president kills that witness, and they say, gosh, that's not obstruction, the witness is dead, but I have the right to do that because I can obstruct this investigation, that's absurd. And that's where the argument sort of leads. There are limits to the president's power. He probably can't just go obstruct an investigation into himself. He might be able to pardon people, but he certainly can't obstruct it.
Do you think he can pardon himself?
I doubt that. Well, the issue there is whether he can be indicted in the first place. And so there's a difference between whether he can be indicted today as a sitting president, or if he's not reelected, could he be indicted under the next president? And then obviously he can't pardon himself at that point.
Well, the Supreme Court has already ruled on that. Clinton, versus Jones, remember that? They said that a president, can be subpoenaed. That was a civil case, though, not a criminal case, and it had to do with actions before President Clinton became president. So do you think that will be litigated, that type of language? Do you think that broadens out from the civil case to a potential criminal case for a sitting president?
This is definitely a new case. It's going to present a new question of whether a sitting president has to abide by a criminal grand jury subpoena for his own testimony. There were similar issues that arose in the Nixon investigation with respect to the subpoena for the White House office tapes. But ultimately, I think that the courts aren't well equipped to deal with that. And that's where Congress has to step in and say, what do we believe is the role of the president and the court, and what does the president have to do to uphold justice? And if Congress doesn't act, I think under our structure, our separation of powers, there's not much that we the people can do about it.
Yeah, and President Nixon was subpoenaed for the Watergate tapes back in 1974, and President Clinton was subpoenaed as part of the Jones situation. Here's another paragraph that the Trump lawyers argue, saying, quote, the president's prime function as the chief executive ought not be hampered by requests for interview. Having him testify demeans the office of the president before the world, ensuring that the office remains sacred and above the fray of shifting political winds and gamesmanship is of critical importance. Does the demean argument go any place with you?
Not with this president. I mean, I think if you look at his Twitter feed just from this week, let alone since January, I think he's done a pretty good job himself of demeaning the office. And so perhaps that might have been a good argument to make if you were representing George W. Bush or George H.W. Bush. It's certainly not a very good argument to make when you're representing President Trump.
Well, a lot of people are going to howl over that comment that you just made, saying that the way he's demeaning the office. I mean, legally, where does that hold water legally if you argue that before the judge?
Well, I think they're running into that issue now. There's litigation about the president's tweets with respect to the travel ban and other types of litigation where he's really run into trouble in the courts about what he said publicly. I mean, it's indisputable that this president has treated his office and the way that he speaks to the public differently. If you look at the way that he pardoned people last week, he's certainly taking a different view of how the president interacts with these powers. They may be permissible, but for his lawyers to then come in and say, gosh, this is really a solemn place, a solemn office that we have to protect his time, because he's doing important things with his time, well, that just doesn't become credible.
So how do you think this will play out? What type of legal battle do you see?
So ultimately, at some point, I think Mueller's going to have to decide whether he pulls the trigger on a criminal grand jury subpoena. I think he is holding off. He has not wanted to do that yet. He'd much rather sit down with the president. He knows that's going to invoke most likely a court battle. So if he does it, the president would have to not respond or choose to respond. And then that would be litigated up through the court, starting at the district court, who's supervising the grand jury, all the way up to the U.S. Supreme Court.
So you see it going to the Supreme Court eventually, potentially?
If this issue becomes live, it will absolutely go to the U.S. Supreme Court.
And what do you think about Rudy Giuliani saying the president wants to testify, but, you know, I mean, the lawyers are kind of handcuffing him?
I think he does. I mean, I think there's been a battle this whole time. When you watch the press talk about the relationship between the president and his lawyers, he has a very different view. He wants to get out there. He thinks he can explain that. I think his lawyers are trying to protect him. They're probably doing the right thing, and they're worried about what he'd say. This is a president who does use hyperbole, who is not very clear sometimes about what he's saying. And if you go into an FBI interview and you do that, you really risk trouble.
That is for sure, and you don't have to be under oath, apparently, to be considered.
That's right. Lying to the FBI is a crime, no matter under oath or in your living room.
Wow. Alex Little, thank you so much always for your
Thank
analysis.
You.